Good morning. Thank you. Please be seated. Thank you for your courtesy. This is the time set for oral argument in our case entitled Wheeler versus Minato. I hope I'm pronouncing that correctly. Our cause number 1, CACV 13-0394. We have reviewed the briefs, reviewed the facts and issues, conferenced the case. We're prepared for your arguments, and we have some questions, and we're interested in what you will be presenting to us. With 20 minutes aside, if counsel for appellant wants to reserve some time for rebuttal, then go ahead and do that. And if you would each state your name when you start for the sake of our recording. This is, I believe, being recorded not only audio but video, and will be posted in due course. Please proceed. Mr. Van Cott, is it?
Yes, good morning, Your Honor. I'm Charles Van Cott. I represent the appellant Kimberly Wheeler in this matter. Ms. Wheeler's appeal does not stem from any issue that the trial court actually considered at the trial in this matter. It doesn't consider an issue with respect to the trial court took any evidence at the trial in this matter. Instead, it concerns language that the respondent and the appellant and the appellee regarding the dischargeability of an attorney fee award that was first raised in an application for attorney fees and costs filed a month after trial. And then after the judge, after the trial court ruled on that application in a minute entry that awarded fees but made no mention of any disposition in bankruptcy, it was then slipped into a form of order lodged immediately after that. That's the order that the judge signed.
The judge did sign that order.
The judge did sign that order.
And there was an objection to it, was there not?
Correct.
And in this specific language.
And in both the response, because he requested bankruptcy language in his application, in both the response to that application and in the objection, Ms. Wheeler wrote that the right question here is not whether this is a proceeding involving children at the trial court level. What she wrote was the right question is whether the court based its award on Mr. Minato's financial circumstances or need, whether it was in the nature of the support, or whether the trial court simply intended a sanction. And I would submit that remains the right question today.
And I'm at a loss to understand why that's the right question, because underlying that question is the assumption that the two are mutually exclusive. I don't see any legal basis for that assumption.
Well, let me explain it, Your Honor, because I think, and I'm going to start in reverse order, I think you have to sort of parse the reasons why ARS section 25324 gives rise to a support obligation in the first instance. And I know state law is not dispositive here, but the bankruptcy courts are advised to look to state court for guidance on the issue.
But that's not our concern, is it?
But that's the issue in the case. And the other.
No, we have no authority whatsoever to opine on the bankruptcy effects of anything that a state court does. That's an exclusively federal issue.
Actually, no, Your Honor. Plaintiff cites cases, Steiner, Rosenberg, Jordan, where this court decided that it in fact has the jurisdiction to determine whether or not a particular obligation
in the nature of support.
Is in the nature of support for purposes of the discharge exception in bankruptcy.
Well,
this court has jurisdiction over that. The trial court has jurisdiction over that. We don't deny it. Our problem with the three cases is none of them had anything to do with attorney fees.
The question whether the trial court in this case certainly had jurisdiction to consider whether its order was in the nature of support. Put the attorney's fees to one side for a moment. But I strongly question whether this court appropriately exercises its jurisdiction to decide whether the determination of the character of the award renders it dischargeable.
But that's what this court did in Rosenberg, Steiner, and Jordan, and in one of the three cases actually it upheld the finding that it was a dischargeable order. The other two, it came out the other way and held That, and again, the cases had to do with, one of them had to do with whether an obligation to pay mortgage payments over time was in the nature of support. Another one had to do with just simply a bulk alimony settlement.
And it may express its intent as to whether the nature of the obligation affects dischargeability, but that can't be binding. You don't have a federal case in which the federal bankruptcy court has said.
You have the Rooker-Feldman doctrine that would preclude the federal court. Under Rooker-Feldman, the federal court has to accept a state court's final finding on an issue like this for purposes of whether or not to proceed with it. Otherwise, we would be in bankruptcy
under the
court now.
Rooker-Feldman doctrine, if this court declared the merger of two cable companies unlawful under the FCC Act, the federal courts would be bound. I think that's a extension of the Rooker-Feldman doctrine beyond its proper scope.
But what we're arguing about here is whether this award is in the nature of support.
Right.
And the answer to that, there are two approaches you could take to that. They would invite you, and by the way, reading the minute entry, there's no doubt what Judge Porter intended. I mean, he was upset. Let's just say that. He was very angry. He believed our client, in his words, perpetuated a fraud on the court. He believed that she and her son worked together to make false allegations about sexual misconduct by Mr. Minotto. He actually awarded his fees despite an express finding that at least going forward, and I would submit at least going back to December of 2012, 2 months before trial, and if you actually look at his AFI before that, that it wasn't need-based, that Mr. Minotto had greater resources, but he made the award anyway. And the other thing that's important for purposes of understanding this is that these findings are at the heart and soul of the trial court's decision on the question of legal, what we now call legal decision-making or custody. That is, if you read through those factors, those are the guts of it. And then when you get to the attorney fee award, he actually refers right back to that very same paragraph where he discusses, these findings as the basis for his award. Now, I do want to say, Mr. Minotto accuses us of continuing to deny the trial court's findings, and we don't, disagree with that. We don't agree with the findings.
But you don't challenge him here.
No. All I would say is if you want us to see kind of where the parties were in terms of this issue, just read the two pretrial statements. The difference is staggering in terms of how this issue was handled at trial. But here we have to explore the ramifications of those findings and whether or not this is, in fact, a support obligation.
Let me make sure I follow, and then perhaps I can add a question as well. Your argument is that we should look at 25324. It has two bases for awarding fees. One is need, and one is unreasonable positions.
Correct.
And need doesn't become a factor supporting this attorney's fees award, you would argue. Need is not. So it has to be based on positions, and from that you're asking us to draw a conclusion contrary to what the trial court said in signing the judgment form that was presented. You're asking us to draw the conclusion that it was solely a sanction.
Yes, but I'm also drawing your attention to what the trial court wrote when it considered that express question, which was explicit, detailed, and couldn't be more clear what he was intending. The other thing is, because again, the question of dischargeability, as you pointed out, it's a federal question, although state court laws, state court decisions are a source of guidance. The fact that it again played so heavily in his decision on the substance of the merits in front of him also argues against the conclusion that it was in the nature of support. Now,
well, the fee award arose out of the trial judge's perception that Mother took unreasonable positions in characterizing a child as a victim of sexual misconduct, right?
Her adult child. Actually, it arose from, in essence, yes.
Okay. If the award was designed to compensate father for money he spent on the issue of child welfare, on the issue of child custody, or whether it's legal decision-making or parenting time. Why isn't that in the nature of support? It relates directly to the best interests of a child.
Well, let me explain the approaches that are available to you. We believe the court should follow the Eighth Circuit's reasoning, and we laid out the Gents case in our paperwork. And it presented a similar situation. The issue there had to do with a mother who was actively thwarting father's parenting time, and so much so that at a point she concealed the child. And the question of whether or not that came up, that the resulting fee award was in the nature of support, what the Eighth Circuit focused on was, and that's what I'm asking this court to focus on, was the intent underlying the award. And in that case, the intent was focused on father and repairing father's relationship with the child. Now, you could make the same argument in that case. He incurred, I think, $7,500. It was an entirely different number. But exactly the same argument would be available there, but that didn't deter the Eighth Circuit from looking at that award and saying, because the focus of the proceedings was not on the best interests of the child. And in point of fact, one of the things that court said was Missouri law, which just as with the law in Arizona and probably everywhere else, sort of says in these kinds of proceedings, the focus is the best interest of the child. So that is not dispositive here. What's dispositive is what the court actually focused on, and it was something else. And in this case, it was something else.
But you notice that the Eighth Circuit is a federal court, considering the consequences of a state court ruling under federal law. And there's nothing to prevent you from making that argument to the Ninth Circuit, but why are you making it here?
Again, because, and actually what we're challenging is the finding that this is in the nature of support. I suppose you've given me an additional reason to attack his additional tack on that were in the order he wrote, and it's therefore non-dischargeable. I suppose we could debate that, but I'm focused on the issue of the nature of this. Is this a support obligation or an award that's support, or is it something different?
I guess here's my question. I don't want to spend too much of your time here, but if you are asking this court to speculate as to whether the judge really intended the order to mean what it says, I don't see how we're in a position to do that. Alternatively, if you're asking us to decide that the court was wrong in its order, I'm at a loss to understand the basis by which we could say it was wrong. As far as the provision declaring something dischargeable or non-dischargeable, I'm inclined to agree with you that that has no place in a state court order.
Well, yeah. Well, let's agree to agree on that one, Your Honor. But with respect to the characterization in that final order that this was meant to be support, respectfully, I guess our argument is that is just wrong, and you can't get there under either the attorney fee statute in Arizona. You certainly can't. In fact, he said it was child support, and I don't see how you get to that conclusion under our attorney fee statute. And also, when you look at it through the lens of how the federal bankruptcy courts look at it, and I want to comment on their approach, which would be just to establish, they argue simply it is all a federal question. There should be a bright line that if it's a proceeding involving children, any attorney fee award should be in the nature of support.
There's no law that says that.
Well, no, that's the Jones case that they cite.
Jones case does not say that any proceeding involving children is automatically has fee awards in the nature of support, and that they are non-dischargeable. That's quite a chain of reasoning. Then there's no bright line in Arizona law.
No, none in Arizona law, but they're citing Jones, and Jones took the position that you don't have to look any further than the nature of the proceeding. Now, they do make an exception for unless they're a clear indication of special circumstances to the contrary. which may, prompt a characterization of something other than support. And I would say we have that here because of what Judge Porter did.
But isn't the law, at least implied by Burt, that it's within the court's discretion to determine whether an award is in the nature of support?
Now, it's interesting that you should raise Burt because, and I want to touch on the Arizona statute. When you look at that statute and understand, because they just dismiss it, they say this is just a plain old attorney fees award under ARS 25324. So what? But and the only Ninth Circuit court on point is Catlow. And it was decided at a time when the only factor in that statute had to do with financial resources. But Catlow is consistent with the way the Arizona courts, including this one, have construed that statute, which is that the support obligation it creates stems from the purpose of the statute, which is to sort of level the financial playing field between the parties. That's where the support obligation comes from. So when you have a situation where, from our perspective, the attorney fee award rests on something entirely different. In fact, he made the award in the teeth of a finding that father has greater resources than mother, at least going forward, that you should reach a different result. And actually, if that distinction didn't exist, the Burt court would have had no reason in its remand to ask the trial court to clarify whether the attorney fee award was in the nature of support or something else.
I guess my point, though, is if Burt makes clear that an attorney fee award can be in the nature of support, and it left to the trial court the determination whether it was in the nature of support, then we are away from the notion that there's a bright line rule. We are squarely within the zone that I suggested, that the trial court has the discretion to look at its fee award and make the determination as to its character is in the nature of support or not. Beyond that, I'm not ready to go to the trial court declaring something non-dischargeable. But
First
isn't
of
that
all,
what Burt says?
Well, I view Burt the other way around, because until you find that language in Burt, you do not find any Arizona precedent that I'm aware of that would suggest that ARS 25324 does anything other than create an obligation in the nature of support. And I would say again, the cases are all lockstep that it's spousal maintenance. It's not child support. It comes from this leveling of the playing field, and all the cases talk about that the duty of one spouse to support the other, including
So are you saying Burt is wrong?
No, Burt actually suggests that there's another way of looking at ARS 25324 in that it could give rise to a support obligation, or more important, that it may not. Because if the statute always gives rise to a support obligation, again, that language, that instruction on the referral back again, and I know the court's aware that Burt also arose from a divorce and then a bankruptcy and then a motion for relief from judgment, and so they're sending it back after a bankruptcy. There would have been no reason for that language if the statute invariably created a support obligation. It does not. Just as with the question under the bankruptcy code, the question of whether or not something is support, it hinges on the intent of the award. And I understand he signed the order at the end, but when you look at it and it's in the totality of his own findings and the evidence that he had in front of him, I mean, that's just not a tenable conclusion to draw. The conclusion is he was angry.
The findings you're talking about are in this 16-page.
Yes, and in particular, paragraph
narrative.
7 of his discussion of the custody factors, and then also in the explanation of the attorney fee award, and in other places too. He is upset.
That may be true, but I take it that you're not launching an attack on the amount of the award.
No.
It's okay.
No. It's
The characterization.
It's the characterization, because under the circumstances that seems gratuitous. And let me also explain, I know I did in the paper, changing the characterization does not get Ms. Wheeler off the hook at all. It simply puts her in a different category of bankruptcy. There's another exception from discharge, it plainly applies to this, which is under 523A15, which is sort of any kind of family court order to pay money, to sort of put it loosely, is not dischargeable under Chapter 7. But what we're arguing for is to give her the opportunity to use Chapter 13 to make this obligation, which right now is unmanageable to her, manageable.
No filing has been made yet.
No. No. We thought that we needed to iron this question out here first before she could go down that route.
You have about a half a minute. Do you want to reserve that?
I better reserve that.
All right. Thank you.
Thank you, Your Honor.
Good morning. May it please the Court, my name is Mark Shields. I represent the respondent appellee James Minato in this case. As I have looked through the briefing in this multiple times, I still find myself in the same position of saying that there simply is no on-point authority for the position that Ms. Wheeler is bringing to this court.
Let me express, probably express my ignorance, but I'll do it anyway. I'm not real comfortable with the idea that an award of attorney's fees could ever be in the nature of child support. Why would that be? I mean, if child support is to be adjudicated, it's to be adjudicated, not dealt with by attorney's fees.
Your Honor, the answer to that question lies in terminology that has been used in various bankruptcy courts and even in appellate courts in this state. The bankruptcy issue, I apologize, it's not a court, it's a legislative issue. That issue deals with terminology domestic support obligation. You know, from there we have case law growing into what is in the nature of support and what isn't in the nature of support. So our main issue here truly is this a domestic support obligation? It doesn't have to do with ARS 25320, which is the child support statute. It simply, is this a domestic support obligation? From there we branch out into synonym terminology such as in the nature of support that has been used to determine whether it falls under that category as a domestic support obligation. We have a very clear stream of case law on that, to that effect, that addresses that issue. I think the keynote case addressing that issue was from this court back in 1974, the Johnson v. Johnson case. That is the case that is cited in the Marks versus Catlow Ninth Circuit decision that is again cited in the Jarsky case that Ms. Wheeler cites extensively. In Johnson, the court specifically found that, quote, fees are as much for the spouse's support as payments made directly to the spouse. And the answer to that question, to dig a little bit deeper, is in Arizona, every parent owes a duty of support to his or her child. Even a parent whose parental rights have been severed still owes that duty of support, unless and until either the child is emancipated or another parent through an adoption becomes the de facto parent. So every time a parent is involved, we have a support obligation involved. Support, therefore, becomes inseparable. It's another end of the stick with a child's best interests, as in this case where we went to court over a child's best or two children's best interests. The litigation was dramatically expanded. Therefore, I see this as the rationale behind the ruling stemming clear back to Johnson. When we pick up one end of the stick, meaning the child's best interests, we're necessarily picking up the other end of the stick as well. That, I think, is the rationale behind that. Now,
but I can see how an award of attorney's fees might be in the nature of spousal maintenance, balancing out between the spouses, or penalizing one of them for taking unreasonable positions. But I'm still having trouble with the I don't want to characterize it as a leap. I'm just having trouble with the step or the connecting of the dots to in the nature of child support.
And again, I will draw the court back to the United States Code, 18 U.S.C. 523A5. The terminology there is not child support, nor is it spousal maintenance. It is simply a domestic support obligation. that's where it's incurred. So I can understand how the court might have different feelings or certainly questions about what has been ruled exclusively, but we have to give those on Capitol Hill credit that they knew what they were saying when they chose to use the term domestic support obligation rather than child support or rather than spousal maintenance. Let me give the court another example, though, that I think might bring this home.
Do our Superior Court judges get to further discern and divide domestic support into child support, spousal support?
Domestic support is domestic support.
But your side submitted a judgment form here that I don't recall that it used the terminology domestic support.
It used synonym terminology in the nature of support, which harkens back to your first question, Judge Gemmel, when we started this.
Was it in the nature of support or in the nature of child support?
I believe it was the nature of support.
So it might not even mean child support.
In the nature, it says in the nature of support for the children, but again, in the nature of support would be the triggering terminology under the domestic support obligation. Here's another way to look at it, Your Honor. Family court is different in many, many ways than any other court. I know.
I've heard that before.
Yes. And while I don't see Judge Swan nodding his head in agreement, he, I'm sure, has memories of those days. When we're dealing with actual children, we're dealing with ones with whom we are all charged with a duty to help, to nurture. Usually we're dealing with litigants of fairly limited means. And because, again, when we pick up one end of the stick, we're picking up the other. We have a parent with, say, a school teacher's salary of $40,000. If that parent is forced to go to court and defend against malicious and false allegations, such as what happened in this case, that parent can either go it alone and take the risk of losing horribly and therefore suffering great detriment for this child, or this parent can go out and hire an attorney. If the parent does go out and hire an attorney, that's money that could have been spent for the child, that could have bought new shoes, that could have sent the child on a vacation to Disneyland or to SeaWorld and could have made some great memories for a child, but instead it's money that has to be spent in litigation, in defending against allegations such as this. I think that is another reason.
In a sense, I think I am following you, and in a sense it doesn't matter which parent the money comes from, the money's gone.
Correct. And in this case, there is a specific reason why the money was gone or why so much of it was gone. This litigation was expanded dramatically over these false and malicious allegations, and not just those allegations, but the cover-up, the conspiring that went with it. It was very difficult, obviously, financially.
Is there any suggestion in this record that the children have suffered a detriment by virtue of the expenditure of these attorney's fees funds?
I think there's more than a suggestion in the record. There is an actual finding that this was incurred over litigation of a child's best interests. And I think that more than answers any question that would properly be before this court. I can tell the court that no, my client, like most clients, regardless of the fact that he has a good income, is not in a position to pay all the massive attorney's fees that were incurred because of this. Therefore, again, by extension, it's a very safe assumption that, yes, that's exactly what has happened. Now, if I can back up a little bit, as I see their argument take shape, I see that they have missed, I believe, the main issue from the very beginning, and that is the domestic support obligation terminology. The references to ARS 25320, and in the reply brief they say that I completely dropped that issue in the response brief. That is not the issue. It never was the issue. Again, the issue is a domestic support obligation. No, it is not child support. This is not a child support obligation that would be adjudicated with guidelines promulgated by the Supreme Court. This is a child custody, a child best interest situation going further. From there, it morphs into this argument about a sanction. I'm at a loss to understand that as well, because not only do we have facts, we have adjudications on this matter. They're clear facts. ARS 25324 is the statute that was pled. It was in the pretrial statement. I believe it was in the initial filings, and it clearly was cited by the judge when he entered this fee judgment. this isn't a sanction. We are not, no one in this room is in a position to read the court's mind and say, well, he did it under this statute, but what he really meant was pure punishment.
Well, we do know that 25324 has two factors.
Correct.
And he made his decision to award these fees in spite of the relative financial standing of the two parties.
And our case law is very clear that he has discretion to do that.
Certainly, but that means he made the decision on the basis of his not liking or his concluding that positions were unreasonable, not liking those positions. And how is that different from a sanction?
First of all, sanctions are specifically governed under other statutes. Rule 31, that's the family law equivalent of the Civil Rule 11.
I understand the word sanction is not
Sure.
in 25324, but is it not at least akin to sanction?
I don't believe it is, because I think the word sanction is somewhat of a term of art, and I'll get to that in a second.
Okay.
But again, I have to remind the court that I don't think it's relevant, because we do know what he held. We do know that this is, in fact, ARS 25324 that was used. That, I think, renders it a moot issue. But let me point the court to the sanction where this notion might possibly gain some footing.
But if you can hold your thought and help me at the same time, when you say 25324 is moot, I'm not quite sure I understand.
I apologize. I mean to say that the issue of whether it is a sanction under some other statute or not is moot, because we know he relied on this statute quite clearly.
Yeah, okay. I guess I didn't think anyone was arguing that it was a sanction under some other statute or rule.
Sure, but again, it's a fee award that falls under the same umbrella as all of the other cases that we cited, again, hearkening back to Johnson v. Johnson.
Well, I guess one way of putting it, and I'm sorry to interrupt, but one way of putting it would be anytime the court bases its fee award exclusively on the unreasonableness of the positions taken by the other party, isn't that a sanction?
Let's get to that issue of sanction, Your Honor, because that is a very good question. By the issue of sanction, I mean to get to the definition of a sanction. It is still, this money is still going, this fee award is still going to compensate the parent of the child who was dragged through this litigation that was not brought or maintained in good faith. Therefore, it still fits the purpose of a domestic support obligation, whether or not we want to call it a sanction. Now, in terms of other sanctions, I can give the court my experience of what I think might be more commonly meant as a sanction where it would not go to recompense the other spouse. I am aware of courts who have ordered for example, once an attorney didn't show up for a hearing, the court in that case ordered him to pay a fine to the clerk of the court. Now that would be a straightforward sanction, and it would not be by any stretch of the imagination under ARS 25324, because it wouldn't go to reimburse the other. But it also wouldn't be
what the courts talk about in this context. It's clear to me that if you read Burt, if you read the Jarsky case that Burt cites, that it's talking about attorney's fee awards incurred in favor of one parent against the other parent. And there is some support in that case for the notion that if the fees are awarded purely as a sanction, they may not be in the nature of support. So I guess the question is, what facts do we have to determine whether this is a pure sanction or something else?
Well, and I would answer that question by again stating that what we have is actually more than a fact. We have an actual finding. And because it is well within the trial court's discretion to make that finding, as long as there are any facts supporting that, that's what we have. And again, the challenge we have here is not to the factual basis of that finding. We have pontification.
Well, by finding, are you talking about the language you inserted into the final form of order or something else?
Correct. Correct. That is it.
Okay, is that a finding or is that a conclusion? Is it finding of fact or a conclusion of law?
I think it would be a conclusion of law that would necessarily be based on a factual finding.
And what factual finding is that? Because the conclusion of law merely characterizes the order. It doesn't give any basis that it's warranted by the factual record in the case.
Well, Your Honor, the factual record in this case is replete from the very beginning, because it starts with a petition to modify parenting time, and that is the whole issue going throughout this. Child support obviously comes along because, again, when you pick up one end of the stick, the other end also rises. So it's clear, I think it's actually even a judicial notice issue, that this case was about a child's best interests. Therefore, that would be the basis for it alone.
Does it matter whether child support was actually litigated in this in this litigation?
Child support was in fact litigated in this litigation. So again, I think that makes the issue moot, but frankly, I can envision cases where in the trial court's discretion, child support might not be purely at issue. For example, if you had a disabled parent where there wouldn't be sufficient evidence under ARS 25320 under the guidelines. If I can back up, I think I can shed some light on this sanction issue. It comes in the opening brief on page 8 in a reference to the Jarsky case, an adversarial bankruptcy proceeding out of Arizona. The quote is, again on page 8, a showing that fees were awarded purely as a sanction, unquote, would allow a debtor in bankruptcy to demonstrate that the fees represented something other than support. Well, 2 points to this. One, it's purely dictum, and two, the opening word in this sentence is omitted, and that opening word is perhaps. So it's not even a finding. It's perhaps, maybe, just maybe the bankruptcy court could envision a case where sanctions might be dischargeable, but that isn't the case.
Burt characterized that as a holding, not as dictum.
If so, I would hearken Burt back to this right here, because this is what the case actually says. It's not as cited and as quoted.
Burt's what this court actually
kind way
said.
of saying that.
Yes, but Burt is what this court actually said, and Burt seems to recognize at the extremes there can be a distinction with a difference.
And there may be, but I can honestly tell the court this is not such a case. This case was purely, unquestionably, about a child custody, formerly known as a child custody proceeding, with terrible accusations that came out that became unbearably expensive for anyone short of a very significant financial means to litigate, and that harkens back to the express purpose of ARS 25324. Even before it was amended approximately 20 years ago to include the reasonableness of the parties' positions. Therefore, it fills every statutory purpose. Again, the purpose brings in resources, and those resources, if they are being spent on litigation, are necessarily not spent on a child's best interests. That is the law, and it is the law throughout. Now, in the reply brief, there is another case cited. It's this Adams v. Zentz. I didn't address it because it wasn't in the opening brief. It was only in the reply brief. I noticed something with respect to the timing in that. That was an Eighth Circuit case from 1992 where the Eighth Circuit said, well, we're going to look at the real motivation behind the litigation. In that case, it appears that they held this was for one parent's, the litigation was over one parent's, I don't want to say self-aggrandizement, but of a personal need for vindication. I don't know. I don't know the facts of that. But I do want to point out that that was a 1992 case that Jones specifically renounced and said, we are not looking at that. We are deferring to the trial court, and again, in this case, the trial court made a clear finding. What is also interesting about the timing of that is it's a 1992 case. I apologize, I just realized this morning as I was waiting to take my time here. We have other case law cited, and I believe it is the Boped v. Chang case that specifically says the Eighth Circuit is in line with this. From that, I can only imagine, and again, I apologize, I didn't think of the argument before this morning, so I could feed the court chapter and verse, but it appears that the Eighth Circuit has since reversed course from this Adams v. Zentz that frankly is the closest thing that Ms. Wheeler is citing to authority. Does the court have any other questions for me?
Thank you very much.
Well, if that's the case, I would like to take, I apologize for backtracking, but I would like to take the last minute to address the attorney's fees issue.
We'll give it to you.
Thank you. Ms. Wheeler comes to this court saying, give me my attorney's fees. Yes, I owe $115 or over $100,000 in attorney's fees, but somehow I believe I should be awarded my fees in this case. I am going to point the court to the same statute relied upon by the trial court, specifically, once again, with respect to the reasonableness. However, I think the resources, that's actually the term used in 25-324, are important also, because my client does not have the resources to continue litigating this case, notwithstanding the fact that his income is pretty good. Again, the reasonableness overrides it. We have a mother coming here to the court without any law to support her position. She's hanging her argument on dicta, plural, from other courts that simply do not match Arizona law, that have never matched Arizona law, again, as I pointed back to Johnson. That is not a reasonable position. I would never want to be in the position of coming to this court and having to admit I don't have any case law on point for my position. That is not a reasonable position. Thank you, Your Honor. Your Honors.
Thank you.
Have to be quick. First of all, our paperwork is replete with case law. I share, Judge Gamble, your sense that I don't see how you reach child support, and whether you call it child support or support for the children is just semantics. Certainly not under Arizona law. And as to the Johnson case, it actually did involve child support. It was a property division case, and in the case, the court wrote, an award of attorney fee to a plaintiff client wife is an adjudication of her need of such support in order to litigate with her husband upon equal basis. I mean, it's in the stream of cases it suggests these create alimony awards, not child support awards. So I don't know.
Although that may harken back more to the original prong in 25-324 rather than the unreasonableness prong, I suppose.
Well, it was decided at a time when that was the only prong, but the point is it does not get you to child support. And then the only other things I would say is Mr. Minotto actually initiated the petition. I would invite you to look at one of the exhibits to our pretrial statement, because back in September, I mean, we were not litigating the case on the basis of these allegations. We pursued a different course. And also, just read the Chang case.
Your time is about up.
My time is up. Chang has absolutely nothing to do with the issues this court has to decide. I'll just leave it there. Our papers explain why.
Yeah,
Thank you.
You've both given us some things to think about, Mr. Bancott and Mr. Shields. Thank you.
Thank you, Your Honor. Thank you, Your Honors.
We'll take it under advisement, issue a decision in due course. Thank you.